The heavy oak doors of courtroom 304 in the Cook County Circuit Court felt like they weighed 1,000 pounds. I pushed through them, conscious of the way my suit fit. It was a charcoal blend I'd bought off the rack at Macy's 3 years ago for entry-level interviews. It was clean, pressed, and completely out of place against the Italian wool and bespoke tailoring waiting for me in the front row. My mother, Eleanor, spotted me first. She leaned over to my father, Robert, whispering something behind a manicured hand. Dad didn't even turn his head. He just checked his Rolex, sighing audibly, his body language screaming that my presence was a tedious interruption to his Tuesday. Next to them sat my brother, Chase, the golden boy. He was scrolling on his phone, looking bored, wearing a suit that probably cost more than my car. And then there was their lawyer, Sterling Thorne. I knew the type. The kind of guy who charged $600 an hour just to breathe your air. He was shuffling papers with the relaxed arrogance of a man who had already won. The bailiff hadn't announced the judge yet. The air was stale, smelling of floor wax and old anxiety. They thought this was a formality. They thought I would walk in, head bowed, apologize for being difficult, and sign the rights to my life away. They thought I was the same quiet, scraping-by kid they'd ignored for the last decade. I walked to the defendant's table and set down my battered leather briefcase. Inside were 3 color-coded folders. They had no idea what was in those folders. To understand why I was standing there, ready to burn down my own family tree, you have to understand the soil it grew in. I was never the chosen one. That was Chase. Chase was the varsity quarterback. Chase was the one who got the brand new Jeep Wrangler for his 16th birthday. Chase had his tuition at Northwestern paid in full, cash, along with a condo in Lincoln Park for networking purposes. Me, I was the spare parts. I worked the graveyard shift at a logistics warehouse to pay for community college, then transferred to UIC on student loans. I lived in a garden unit in Rogers Park, which is a polite way of saying a basement with bars on the windows and a radiator that banged like a hammer all winter. I wasn't bitter. Honestly, I wasn't. I just learned the lesson early. You are on your own. But Grandpa Frank saw me. Frank was my dad's father, a retired machinist who had calluses on his hands until the day he died. He was the only one who showed up to my graduation. He was the one who took me to a diner every other Sunday for eggs and coffee. "You're the one with the grit, Mason," he told me once, tapping the table with a thick finger. Chase has charm. Charm is like cheap paint. It peels when the weather gets rough. Grit is structural. Grit holds the house up. Grandpa Frank was paranoid in the way people who lived through hard times are. He taught me to document everything. Keep your receipts, kid. Every email, every contract, every bank statement. The world is full of people who will smile while they pick your pocket. Trust, but verify. I thought he was just being a cranky old man. I didn't realize he was arming me for war. When Grandpa Frank passed away last year, the reading of the will was exactly what I expected. Chase got the lake house in Michigan, Mum and Dad got the primary investment portfolio and the vintage car collection. I got the education and betterment trust. At the time, it sounded like a token gesture, maybe 10 grand to pay off some loans. Then the executor explained the details. Grandpa had seeded that trust 25 years ago with aggressive tech stocks and let it sit. He never touched it. The dividends reinvested automatically. The value was $1.4 million. The silence in the lawyer's office that day was deafening. My mother's face went the color of ash. My father looked like he'd swallowed a lemon. That was the moment the dynamic shifted. That was the moment I became a target. 2 weeks later, the call came. "Mason, come to the house in Evanston. We need to have a family discussion." I drove up there, feeling the old knot of anxiety in my stomach. When I walked into the living room, it was an ambush. Mom, Dad, Chase, and a man I'd never met, Sterling Thorne. "This is for everyone's benefit," my mother said, her voice dripping with that fake, syrupy concern she used when she wanted something. Thorne slid a document across the mahogany coffee table. "The Vance Family Consolidated Asset Management Agreement." I scanned the legalese. It was a trap. It stipulated that I would voluntarily transfer my trust into a family-controlled pool. They would manage the investments for the legacy of the family. In return, I would receive a monthly stipend of $2,500. "You've never been good with big-picture finances, Mason," Dad said, pouring himself a scotch. "You're working class. This kind of sudden wealth, it ruins people like you. We're protecting you from yourself." Chase chimed in, leaning forward, elbows on his knees. "Don't be selfish, Mace. Grandpa would want the assets kept together. It's about the legacy." I looked at the paper, then at them. "And if I say no?" The temperature in the room dropped 20 degrees. "Then we do this the hard way," Thorne said smoothly. "We can file a petition with the probate court for a conservatorship. We can argue that you are financially incompetent to manage this level of liquidity. It would be public. It would be embarrassing." He let the word hang there. Embarrassing. "You have 72 hours to sign," Thorne said. I stood up. I didn't yell. I didn't flip the table. I just said, "I've decided," and walked out the front door. I didn't wait 72 hours. I went home and started digging through the fireproof box under my bed, but they were faster. 3 days later, a process server caught me leaving my apartment. He handed me a thick envelope. Inside was a 14-page petition filed in Cook County Court. They were asking the judge to declare me incompetent and appoint my mother as the conservator of my estate. The allegations were fiction, reckless gambling, substance abuse issues, inability to hold steady employment, all lies. But they were notarized lies, filed in a public court docket. The fallout was immediate. My boss at the logistics firm called me into his glass-walled office the next morning. He held a printout of a background check. "Mason, we handle sensitive client data here. Fiduciary responsibility is key. We have a flag on your record regarding a pending competency hearing." "It's a family dispute," I pleaded. "It's retaliatory." "I believe you," he said, looking down. "But HR policy is strict. We have to place you on unpaid administrative leave until the legal matter is resolved." I walked out of the building carrying a cardboard box of my belongings, stunned. They had actually done it. They were willing to destroy my livelihood to get their hands on Grandpa's money. That night I sat on my floor, surrounded by despair. My friend Sarah texted me, "Just give them half, it's not worth the war. You can't beat them." I almost listened, but then I looked at the bookshelf. There was an old, tattered binder Grandpa Frank had given me years ago. He called it the Vance Operational Manual. It was mostly receipts for appliance repairs and warranties, but he had a section for the trust. I opened it to page 12. My heart stopped. Section 7, subsection D, the no contest clause. I read it 3 times to ensure I wasn't hallucinating. If any beneficiary under this trust contests the validity of this instrument, or initiates legal proceedings to alter the distribution of assets, or seeks to impair the share of another beneficiary, said beneficiary shall forfeit their entire interest in this trust and the estate. And there, in the margin, in Grandpa's blocky blue ink, "Poison pill, kiddo, just in case the vultures circle." He knew exactly who they were. I called up an old buddy from my undergrad days who worked as a paralegal. "Check this citation," I said. He confirmed it. "It's an in terrorem clause. In Illinois, these are strictly enforced if the challenge is brought without probable cause or in bad faith. If they are suing to take your share, and they lose everything. The lake house, the portfolio, the cars, it all goes back into the pot and redistributes to the remainder man." I drafted a letter that night, sent it via certified mail. I included a photocopy of Section 7, subsection D. "Withdraw your petition within 48 hours. If you proceed, I will move to enforce the forfeiture clause. You will lose your inheritance." I thought that would end it. I underestimated their desperation. They didn't withdraw, they doubled down. Thorne filed an amended petition. This time, they weren't just attacking me, they were attacking the trust itself. They submitted a document, a codicil, an amendment to a will, trust, dated 4 years ago. It claimed that Grandpa Frank had been confused and had signed a document stating that all assets should be consolidated under Robert and Eleanor's control for family harmony. They attached a statement from a doctor, some guy who had seen Grandpa once for a flu shot, claiming Frank showed signs of dementia. It was a lie. Grandpa was sharp as a tack until the aneurysm took him. Then Chase took to social media. He posted a photo of Grandpa on Instagram, fighting to protect Grandpa's true legacy from those who would manipulate his memory. "Mental health is real, guys. Pray for my brother." The comments made me nauseous. "So brave, Chase." "Money changes people. Sorry you're going through this." I was isolated, unemployed, publicly shamed, but I had Grandpa's lesson. Keep the receipts. I looked closely at the digital copy of the codicil they had filed. The date next to Grandpa's signature was March 12, 2019. I pulled the original trust document from my binder. I compared the notary stamps. They were different. The original was notarized by a Timothy G. Miller. The new one was notarized by a Janice K. Lee. I hired a private investigator for $500. He found Timothy Miller in Arizona. I got him on the phone. I keep a log of every stamp I've ever pressed, Miller told me. I never notarized an amendment for Frank Vance. Then I looked at the codicil again, the paper. It looked standard, but at the bottom, in microscopic print, was a batch code for the paper manufacturer. I spent 6 hours on Google. That specific batch of bonded legal paper wasn't manufactured until 2021. The document was dated 2019. It was a forgery, a sloppy, desperate forgery. That's when the pieces clicked. Why were they risking federal fraud charges? Why were they coming after me so hard? I went back to the public records. Cook County Recorder of Deeds. I searched my parents' address. Notice of default. Foreclosure proceedings initiated 3 months ago. They owed the bank $480,000. I searched Chase's successful tech startup, dissolved by the state 6 months ago. Outstanding judgments from vendors totaling $300,000. I checked my dad's investments. He had been heavily leveraged on margin when the market corrected. He was wiped out. They weren't just greedy, they were drowning. The $1.4 million in my trust was the only life raft left, and they were willing to hold my head underwater to grab it. I didn't feel anger anymore. I felt a cold, surgical precision. I spent the next week preparing. I didn't sleep. I drafted a counter-petition for breach of fiduciary duty, fraud, and enforcement of forfeiture. I prepared 3 exhibits. And I hung a framed certificate on my bedroom wall, one I hadn't told a soul about. "All rise," the bailiff boomed. Judge Holloway swept in. She was a terrifying woman with reading glasses perched on the end of her nose. She sat down and glared at the file. "This is the matter of the Vance estate. We have a petition for conservatorship and a counter-petition regarding fraud?" She looked over her glasses. "Yes, Your Honor," Sterling Thorne said, standing up and buttoning his jacket. "We believe the counter-petition is frivolous, a stalling tactic by a troubled young man who—" "I'll hear from the respondent," the judge cut him off. She looked at me. "Mr. Vance, are you representing yourself, or is counsel running late?" I stood up. My hands were steady. "Your Honor, I am appearing pro se in my capacity as the beneficiary, but I am also counsel of record." The room went quiet. Thorne frowned. "Counsel of record?" the judge asked. "Yes, Your Honor. I passed the Illinois bar exam in February. I was sworn in this past May." A gasp, audible and sharp, came from the front row. My mother's hand flew to her mouth. Chase stopped scrolling on his phone. I had gone to law school at night for 4 years. While they were vacationing in Cabo, while they were ignoring me, I was studying torts and contracts. I hadn't told them because I knew they'd mock it, a night school degree from a second-tier university. But in this room, the degree didn't matter. The bar card did. "Proceed, counsel," Judge Holloway said, a hint of interest in her eyes. I opened the first folder. "Exhibit A, Your Honor, Section 7, Subsection D of the original trust. The forfeiture clause. It states that any beneficiary who challenges the validity of the trust in bad faith loses their share." Thorne jumped up. "Your Honor, this is not a challenge to the trust. It is a petition for—" "Sit down, Mr. Thorne," Holloway snapped. I opened the second folder. "Exhibit B, Your Honor, the codicil submitted by the petitioners. They claim it was signed in 2019. However, I have here a sworn affidavit from a forensic document examiner. The paper stock used for this document was not commercially available until 2021. Furthermore, the signature has been identified as a digital trace, not wet ink." I walked the documents to the bench. The judge took them. The silence in the room was absolute. You could hear the hum of the air conditioning. "This is a forgery, Your Honor," I said, my voice projecting clearly. "Created to defraud this court and seize assets to cover the petitioner's significant undisclosed debts, which I have documented in Exhibit C, public records of foreclosure and business default judgments." Judge Holloway flipped through the pages. Her face grew darker with every turn. She looked up at my parents. They looked small, shrunken. My father was pale. My mother was weeping silently. Chase looked like he wanted to vomit. "Mr. Thorne," the judge said, her voice dangerously low, "did you know about the provenance of this document?" Your Honor, I was provided the documents by my clients. I had no reason to doubt." Thorne was stammering. He was watching his career flash before his eyes. "This petition is dismissed with prejudice," Holloway ruled, slamming the file shut. I am granting the respondent's motion to enforce the forfeiture clause. The petitioners have acted in bad faith and have committed fraud upon this court. They are stripped of all interest in the Vance estate. She paused, looking directly at my father. Furthermore, I am referring this matter to the State's Attorney's Office for investigation into forgery and perjury, and I am imposing sanctions on the petitioners in the amount of legal costs incurred by the estate. We are adjourned. The gavel banged. It sounded like a gunshot. I packed my briefcase. I didn't look at them. As I turned to leave, my mother reached out, grabbing my sleeve. "Mason, please. We'll lose the house. We'll lose everything." I looked at her hand on my cheap suit. Then I looked at her eyes. I didn't see love. I saw a drowning woman looking for a ladder. "You should have read the binder, Mom," I said gently. Section 7. I walked out. The aftermath was swift. The forfeiture clause was ironclad. My parents' share and Chase's share of the estate, the house, the stocks, the cars, were seized. Per Grandpa's instructions for a failed gift, the assets were redirected to the secondary beneficiary, the Machinists' Union Scholarship Fund. My parents lost their home to the bank foreclosure 2 months later. They moved into a 2-bedroom rental in a strip mall suburb. Chase filed for Chapter 7 bankruptcy. He's working as a shift manager at a car rental agency near O'Hare now. The state's attorney declined to press criminal charges, mostly because they were already financially ruined. That was punishment enough. I took a portion of my trust and paid off my student loans. I bought a small, sturdy bungalow in a quiet neighborhood. I quit the logistics job and opened my own solo practice, specializing in elder law and estate litigation. I help families protect themselves from, well, people like my family. I haven't spoken to them since that day in court. My mother sent a letter last Christmas. No apology, just a "hope you're happy." I burned it. I keep Grandpa Frank's picture on my desk. It's the one Chase tried to use against me. But when I look at it, I don't see a victim. I see a man who knew the score. He taught me that sometimes the only way to win the game is to be the one keeping the scorebook. So here's the question I have for you. If you were holding the winning hand, would you have played it? Or would you have folded to save the people who tried to ruin you? Let me know in the comments. And if you've ever been the underdog who had to bite back, hit that like button. Remember, trust but verify. And always, always keep your receipts. Disclaimer. This is a fictionalized dramatization based on real events. I am a lawyer, but I am not your lawyer. This is not legal advice.